Hello and welcome to yet another episode of In Conversation. My name is Slindelo Masikane. I'm an award-winning broadcast journalist as well as a producer. Currently, I work for South Africa's most watched independent 24-hour news station known as eNCA or eNews Channel Africa. Now, I am honored to be here on UJTV, and today I'll be unpacking, in essence, what we're seeing transpiring with our justice system, as well as a number of court cases that I think have had South Africans talking, as well as social media. And of course, I'm no expert. We need to unpack this with somebody who knows a little bit more about the law. I'm joined by Mr. Elton Hart. I think you guys will know him better. Mr. Elton Hart from the UJ Law Clinic. Thank you so much for your time.
Thank you, Slee, and thank you to the viewers for tuning into In Conversation. And this is where we're going to unpack and unravel the headaches that we've seen unpacking in court cases.
Yeah, so it's been quite an interesting year in terms of what we're seeing transpiring in our court system, as well as the court cases that the courts are seized with. Let's just start with, I think, what we're seeing with this trial of the century. You know, I don't think we've seen a trial of this magnitude since Oscar Pistorius. We're talking about the Senzo Meyiwa murder trial. This is a trial that's about 10 years in the making. Talk to me about where we are with the trial, where we started and where we are now. Initially, in 2022, we had a trial before Judge Maumela. We now have the trial starting over in 2023. Why?
Now, obviously, one looks at it, and obviously there were certain issues pertaining to Judge Maumela, why the president has removed him, because there was allegations that he took too long to actually give certain judgments. And obviously, once a judge has been removed from his office, obviously the matter still needs to continue. And because of the nature of the evidence that was tendered in this case, it became very difficult for a new judge to say, okay, I'm just going to take the baton from Judge Maumela and run with it. Because with witnesses, normally you have to look at the body language of witnesses, what we refer to in the legal circles as the demeanor of the witnesses, to actually at the end of the day to come to say this was a credible witness. He was telling the truth in court, and that makes it very difficult for a judge to just pick up. And even sometimes you get judges, they like doctors, they write very ugly, so you can't really decipher their notes, and you don't know if they made maybe an X on the sheet, what it actually meant. So that is why they had to actually start. But obviously, if you look at it, and I think South Africans are at that stage where they feel actually tired because this trial is taking so long. And I mean, for me as a legal expert or a legal person, to actually follow, it's a lot of things, dots that you have to connect, remembering what was said and actually bringing them together. And now we know certain things were said in the first trial, if they say 1.0, and now we're on 2.0. Hopefully we don't get to 3.0. That you have to remember, what did the witnesses say there? Was their story the same? Because that can give you also an idea as to, are they telling the truth? Is this a fabrication? So that is all the things that one has to look at and remember, and trying to keep them together. And if you are not legally trained, it becomes an exercise.
Now, we know, of course, that this trial is a trial that has two dockets, something that I believe, or I've been told by legal experts, is unprecedented, to have a trial or a case where we have two different dockets that are essentially saying two different things. We have one docket that says the 5 men on trial are the ones responsible for the murder of Senzo Meyiwa. We have another docket that says there were no intruders, that someone in the house shot and killed Senzo Meyiwa. Of what significance does this issue have for the trial?
No, that's actually serious, because what one can look at it. Say, for instance, if we look at the docket 636, that first docket, if you look at it, and that is the 5 guys that's currently on trial. If those guys get acquitted, and for some odd reason they come with docket 375, then the guys that's going to be accused in that new docket, the 375, the later docket, say, but we told you that is the guys that actually killed Senzo Meyiwa. So then both sets of accused might be acquitted, and that is the predicament that we sit in. And now the first docket and the second docket, to have two dockets that emanates from the same cause of action. It's the first time that I'm seeing this happening. That you have two sets of investigating teams within SAPS investigating the same cause of action and then sort of half coming to two different sorts of who is the possible suspects. That in itself, it indicates to me, in SEPS, there is a factional battle within SEPS that says maybe there's a plot to actually make sure that the real perpetrator, the real person who actually shot and killed Senzo Meyiwa is never brought to book. And I think the man on the street also sits with us. Why is there two dockets for the same thing? Because this has never happened. And for me, that creates a lot of problems because now you can see also as the matter unravels in court that Advocate Baloyi is focusing more on the evidence from the first docket and sort of not even touching on possible evidence, and he has it at his disposal. And for me, the role of a prosecutor is not to make sure the person in the dock is convicted, but to make sure justice prevails, that we really know what happened. And that is the predicaments that we struggle with. And for me, this two docket scenario, they should have sorted it out. The NDPP was supposed to look into say, okay, we're just going to take this docket, that other docket be removed and the evidence be collated and put in one docket. And if it meant that we had to have 12 accused persons, so be it.
Talk to me then about the manner in which the state is leading or presenting its evidence before the court. The state has on many occasions been accused by the defense of being underhanded, of not being forthcoming or open with the evidence that it wants to lead. We're also seeing questions around why the state didn't call everyone who was in the house to come and testify. In particular, of course, Kelly Khumalo, who's now been implicated in terms of cell phone records that are linking her to one of the accused. We know that the state, in essence, is the dominus litis, if I'm using the correct legal term. So the prerogative lies with the state in how it wants to present its case.
No, that's indeed so. And nobody can tell the state on the sequence how it can call its witnesses. Similar, the defense can also call its witnesses in any sequence. But what I've picked up, and specifically the last 2 weeks, was a clear-cut, underhanded ambush litigation that the state is currently using. Because you cannot tell me, I've been sitting on a statement of Constable Zungu for more than 4 years. I knew that he's saying he saw all 5 accused in Vosloorus at the Sutu hostel on that specific night that Senzo Meyiwa was killed. Why am I not making it available to the defense teams? And if we say we want to protect his identity, his safety, and all, we can redact his name. We can redact his address. We can redact his ID number, but say there is a witness. We're not going to disclose his identity. That's going to say 1, 2, 3, 4, 5, 6. Then they could have taken instructions from the client. Now we see in court that lawyers has to, while they're busy cross-examining, they have to stop because the state is coming with ambush litigation to go and get an instruction. And what I've seen from the judge is like when these guys want to consult with their clients, he's sort of getting irritated with them. He's not sort of half looking at these guys are in a sort of, it's a unique situation because these guys are in custody. It's not that I can walk over to my client's house and actually get or consult with him, get his evidence or get his answers pertaining to evidence that is put against us. They are in prison, so I need to phone the prison authorities, make an arrangement for a consultation and make sure wherever I consult with him, it's conducive for a consultation. All those type of things. And you see the irritation in the judge with the defense teams. And that for me, it's not like a fair trial as guaranteed in Section 35 of the Constitution. They need to give. And the state, and I actually expected the judge at some stage to also chastise the state to say, listen here, if you have not fully discovered, let's stop the case right here. Go check your docket, check what evidence you're going to present, make all the evidence that you think you're going to present available to the defense, let them consult, properly consult, take instructions, and then we put this trial back on the road, and then we run. But now I see they coming wishy-washy, and just yesterday, the prosecutor gave the defense to say, okay, I'm going to use a pro forma form, which has been redacted. I'm just going to use that. And then the next morning, he suddenly said, no, I'm going to use the audio as well. So that backwards and forwards as to, yes, I know the lawyers also, for the accused persons, they need to prepare for all contingencies. But if you say you're not going to, because we are pressed for time, resources, these guys that sit in the dock is not that well resourced. So there's this type of problems. But obviously, we'll still see how the trial unravels. And for me, the interesting part is when the defense is actually going to present their case or their version, then maybe a lot of things, what we now see is damning evidence, might be seen as, oh, it's not really damning. But that's only time will tell.
Talk to me about the importance then of having a judge that's impartial, or a judge in the very least that comes across as being impartial, because I think on the surface, many South Africans or those following the case are seeing some kind of unfairness, perhaps, in terms of how the judge is treating the state as well as the defense.
No, indeed. So if you look at it from the outside, and you can sense there's a sort of people are sensing some sort of bias from the judge's side, because when the state asks for indulgence, he's not lecturing them about certain things. And I mean, there was one incident where Advocate Mshololo, she normally speaks loud. She speaks loud, and she was like, he was telling her, but don't shout at me. And she said, but that's my normal voice. That's how I ask questions. And for me, also the one standout moment for me was when the judge actually picked out a SCA judgment, read paragraph 3 to say a judge is responsible for managing a trial, and trying to dictate to the defense attorneys as to how they need to actually put their versions across, how they should be doing. If you want to help, if you want to enter the arena, it must be to the benefit of the accused persons. So now he was dictating, and you could see that there's some sort of irritation on him, because when he's rolling his eyes, he's sketching, and that for me was not. And that judge, what he did not do, and what the South African population doesn't know, he did not read paragraph 4 of that very same judgment he was quoting to the people. What there it says, a judge should manage, and not, there's a fine line between managing a trial and entering the arena. And for me, at some instances, you could see he was entering the arena. Then he would say, I'm asking clarity-seeking questions. But you can see he's sort of half covering something that the state has must, to actually, for the state to have a bite to bring that evidence in. And for me, it's like, if you're not legally trained, you won't see it. But we are legally trained. We can see that these things, if you do it for the state, if you say, okay, I'm helping the state to clear up something. Now, if the defense doesn't ask a question to one of the witnesses, why are you also not seeking clarity on certain things? Then you sit idle and say, okay, the witness has testified. And you could even see with the new attorney for 1 and 2 came on. He said, I want to re-examine. Then he allowed them, and the next day he's now throwing a brick wall against, no, he was already cross-examined, you can't. And then he quotes the sections, but he quotes the sections in such a way that it suits the version or the view that he wants to get across to people. But if people just do their own work, go draw the Criminal Procedure Act, you'll see something different. You need to read something. And that's the thing. And I say a judge needs to be impartial at all times.
Let's talk about the attention then that this trial is getting, and the significance that it has on people's perceptions of the criminal justice system. There was a lot of back and forth in terms of the media being allowed in court, how they were going to conduct their work, how they were going to be able to broadcast this particular trial for South Africans, and of course for the family of Meyiwa who's seeking justice for Senzo. Is the presence of cameras in court an assistance or a hindrance in terms of the administration of justice?
This can be a two-cutting-edged sword. It can be a hindrance because some people, they are on their nerves when they see the cameras. They would not talk and give evidence as they would give if there's no camera. But also the cameras being there, it makes sure that the rights of the accused persons is not infringed upon, that we don't know. Because I've been in many courts, then you can see how magistrates and judges would actually deal with these people, how prosecutors would deal with the accused people and actually trampling upon their rights. And for me, having the media there, it also gives a sense of sort of how it levels the playing field to a certain extent, that you make sure that their rights is protected, everything is explained to them. Because this is the first time that I see a judge try and explain so many times that he says, okay, I need to give fair trial. But in explaining that, for me, it's red lights flickering already. But it helps a lot. And it also, you know, this is a case. It was one of our national team players. He was a captain for our national team. So people down in Uppington in the Northern Cape, they knew Senzo Meyiwa. For them, Senzo Meyiwa was a hero. They want to know what happened. They don't have the means to get to the courts in Pretoria, but they want to know. So the media's role in actually making sure that the public is informed and to see how the justice system operates is a good one for me. And even for me, I always don't have time to actually go to Pretoria and sit in court and actually listen to what's happening, so that I can also give my analysis or analyze the case for me to see where it's going, because I also have an interest in the case, because it's something big that happened to a soccer star of ours. And it helps. So for me, if the media wasn't there, I would not have insight into the case. South Africans would not have an insight into the case. And then that confidence that we would have in the justice system would just diminish.
I mean, I think it speaks to the idea of justice needs to be seen to be done, which I think is a phrase I hear quite a lot when magistrates or judges allow cameras inside court. Let's pause on that for a moment and then talk to me about the evidence that we've seen being led so far. In particular, we have a hat which allegedly belonged to one of the intruders that was left behind. Seemingly, the DNA of the accused doesn't 100% match any of those who are in the dock. Then we have the description or the identikits of the alleged intruders. We have a dock identification that's been done, and we're also seeing cell phone data records that are at play as well. How does this all then tie into what the state is trying to prove? Because from the surface, or from what I'm seeing, it does seem as though the evidence is quite circumstantial as opposed to direct links of the 5 men that we're seeing in the dock to the murder scene.
No, indeed so. The evidence that the state currently have is just circumstantial evidence at best that one can have. And the first cell phone analyst that was called, I think it was Colonel Albertus Stein or something, that came and they tried to use cell phone sort of using the cell phone signals that they got from the towers. Now, what we refer to is cell phone triangulation, that you'd use 3 points to say that a person was in that angle. And that evidence could not clearly put them in the vicinity of the Vosloorus home of the Kumalos at that point in time. So that is like, it's a give and take situation. It's a give and take situation. The DNA, obviously, and our criminal system is built on this, there must be beyond reasonable doubt. So the mere fact that the DNA speaks to, like, yeah, there is some markers that lines up, but not 100%. DNA is unique to a person. So if it doesn't line up, then it means there was a mix of DNA. It can be even that you and me are related. We don't know because of our ancestry back then. And that's why our DNA might have some markers that's the same. And that shouldn't be seen as damning against the accused. It should actually be seen as sort of making it more difficult for the state to come and actually... And I see now the state wants to even bring in a new cell phone analyst. And I don't know what... we'll only find out the type of evidence that he wants to bring. Because I think the new cell phone analyst, they want to link it to Zungu's evidence to say Zungu saw them there, and on the cell phone towers, they were picked up there. But I already saw that the defense team was saying, yes, we were in the first, but at another hostel, not the hostel that you're saying. And the people that you're saying was in the pictures is not you, it's somebody else, where you claim to be in the picture, because there was also discrepancies in how Zungu did. So all these types of things, when one looks at it cumulatively, it is creating doubt. And if there is doubt, the benefit should be given to the accused persons. That's just how our criminal system is, rather to let a person that might be guilty go than to have a person that's not guilty incarcerated. And that's how one needs to look at the evidence. And this is now in conjunction with the oral evidence that was given, that they say that this head was worn by one of the intruders, and now you can't match it to these people that's in the dock. It sort of half casts doubt on the evidence that the state is bringing in. For me, there's not direct evidence that you can say, okay, this one can clearly say up there. And there's this Ngubeni ladies that they have something different to say that they found Mapiri was busy cleaning the crime scene. So for me, that working of the crime scene, that tampering, because I remember back then the judge said, he asked one of the people, are you disputing what you see in the photo? And they just didn't articulate themselves properly to say, yes, we dispute, because what we're saying, what you see in the photo was not directly what was there after the crime was committed. And they just had to articulate. And sometimes I think the defense teams, they just don't articulate themselves properly in English. And we can understand it's not the guy's first language, so I don't hold it against them. It's just to get that finer points across so that you zoom into cross-examination. But I hope things will get better as we proceed.
Let's talk about the defense then. Just how difficult of a task is it for them to cast doubt, to get these guys off the hook, essentially. It seems as though the state is really not holding anything back. And at this point, just how far are we from the state perhaps finishing up with the evidence it wants to lead, and where are we with the defense then coming in to, in essence, unravel or, cast doubt in terms of the guilt of these accused?
No, for me, the state is still far. And where we stand currently, if the judge, in all fairness, looks at the evidence, he should be giving a Section 174 to the accused persons. Because I don't think that the state has proven beyond reasonable doubt that these people are the persons that actually committed that crime.
So what is a 174?
A 174 is when the state has led all the evidence that they think is necessary to get a conviction. Then you bring an application in terms of Section 174 to say, okay, this evidence that is put before court is not enough to show to the court there's a prima facie case to which the defense has to come and respond. And then they can be asked to be discharged, and then they're free to go. So I think at this stage where we're at, we're there. And for me, the defense team they don't need to prove that they're not guilty. The state needs to prove that they are guilty beyond reasonable doubt. So if they would come and bring evidence to say, oh, on that day, when you say we were in the Soto hostel, we were somewhere else. This is our witnesses. If they can bring alibi witnesses, and I think the only problem that they have, they were supposed to actually go to the cell phone providers to get their data themselves, to say, here's our data of our cell phones, where it pinged off. And I could see the guy from HR, from Anglo Gold, that was called to come and say, and the state wanted to make a big thing about Mtanzi not being at work on that. He was on leave. He has no need to report. He has nothing to prove. The only thing that Mtanzi needs to do is he needs to go to KZN, get photos of the rituals that was performed at home, say, yeah, I am. And the photos that the state put in, I could not see date stamps on them. So you can dispute the genuineness, the authentication, when those photos were taken. You can even say that photo was taken 12 years ago. It's old photos. So they need to look in those type of small areas, and then they can actually sort of have overthrow the state's version or narrative that they're trying to portray to the court.
Let's talk about accused Bongani Ntanzi. His case is quite interesting in that of the 5 men in the dock, he is the only one with no previous conviction, no pending cases apart from this trial. When he was arrested, he was somebody who was just working in a mine. So he's been incarcerated essentially since 2020. Looking forward, let us say Section 174 is granted, or the judge finds that there is not enough evidence to prove the guilt of the men on the dock. What kind of measures or what options does Ntanzi have for, in essence, his life being put on standstill, in essence destroyed? I mean, he has no job, and he's been in jail for 3 years now, in essence. What kind of measures can he take against the state?
No, obviously, as most of the people would know in South Africa, you sue the state, and be it now the police, be it now the correctional services, you can even sort of have the people, even now the magistrates or judges who denied bail, they can also be brought in. Obviously, you need to get special permission to actually sue them from the judge presidents, from the various courts. So they can sue for loss of income, loss of liberties, all those type of things. Also the years that he has lost, I think, with his child, because I think his daughter is like fairly young, and it's now 3 years. She's grown up a little bit. He hasn't seen her properly, like growing up, being there, just to have that family life, all those liberties that was taken away from him. It's in the form, you can capture that all in the form of damages, and actually bring a damages claim against the state in the various departments who actually incarcerated him. And I think even a name that pops up a lot that you would also know is Gininda. We all hear Gininda, yes. It pops up. And I would think that if I'm accused number 2, I'll also put him up as one of the defendants in my claim. Because every time when you hear something, there was maybe a where he alleges he was tortured, Gininda's name is there. When he was taken, Gininda's name was there. When it was on the crime scene, Gininda was there. Evidence was Gininda was there. So he needs to come and answer or be held accountable. And Gininda being the prominent figure in this whole dockets, we don't see him in court. So I would say sue the state and bring in all these defendants that sort of had a role in your being incarcerated, evidence that was put against you. Obviously the judges, when they look at bail applications, they look at the bail application, but if you can prove that maybe how they looked at your application being a first time offender, all those type of things, and you were denied bail, bail is not a punitive measure. Bail should be just to make sure that you will come to court and they could verify his address, he was working, those type of things. So you would have that claim.
Yeah. Then maybe before we wrap up, the significance of the confessions that want to be used by the state. We're seeing a lot of back and forth around the defense really not wanting these to be admissible as evidence. What conditions need to be in place for a confession to be recorded and for it to be admissible in court? And from what you've seen in the Meyiwa trial, can these alleged confessions be admissible?
No, they can be admissible, but one needs to check, was it made freely, was it made voluntarily? And the mere fact for me, the thing that that sort of sparks a red light with me is like the accused, especially accused number 2, when he got to the magistrate, he said, can I have a bath? Now, I know if you want to torture somebody, you don't give them bath, because it's small little things that you put the light on, you put him in a room, you keep the light on, he doesn't bath. All those things, it wears a person down. And he said he was taken to some building that looked like a municipal building, and they used the old apartheid trick to actually pull a plastic bag over his head. That's not something you can see on a J88. So for me, it's not clear-cut. It looks like damning evidence, these confessions that they have, and you can see sort of how the state is pushing at all levels to actually get it in, because they don't have anything else. Because if this confession is admissible, then they can say, okay, you've admitted that you've committed the crime, so that's on that basis we convict you. But if that is not in, they have a difficult task to actually prove these 5 accused was actually the ones that actually responsible for Senzo Meyiwa. So they can bring it in, but obviously, but I also felt like the defense team was not doing justice, especially for accused 1 and 2, in the cross-examination of these witnesses. They needed to still grapple with them, hold them there in the box and actually ask a lot of things. And obviously, I also see that the magistrate that took down confession number 2 for accused number 2, she did it in her office, and it seems like she did it on her phone. So you can also maybe challenge the genuineness, the authenticness of that recording. Is it still in the original format? Was it really? Was it not altered? Those type of things. For accused number 1, what sort of drove my attention, and I don't think a lot of people, we had this constable from the Ekurhuleni, SWAT. Now, if we know Ekurhuleni, Boksburg is on the other side of town. You bring somebody from Boksburg to come to Everton, which is here by Soweto, to take somebody to Diepkloof for a confession. Can't you phone somebody from Diepkloof to say, come fetch him here by Everton, take him there and bring him back? Then it speaks to what accused number 1 said, that this guy, this constable, he was there when they were arrested, he was all involved. And then one can most probably say, but I would have asked him, you were there, to say that you were part of this team that tortured me. And maybe to look into that. But I thought the defense sort of let the accused down there in the cross-examination. Maybe the court will allow Colonel Mboto and this constable from this SWAT team to be sort of re-cross-examined.
Yeah.
Then maybe they can actually tackle and take up those issues. Then I think it might help so that they can get it inadmissible.
So in your opinion, are we seeing a fair trial, and could we see this trial wrap up by the end of the year?
Wrap up by the end of the year is not going to happen. Fair trial, I don't think so, because I can see there's certain things where you can just see how the prosecutor is presenting his evidence and how he's making it available to the other side is not fair. And as I said earlier, the prosecutor's role is not to prosecute everybody that goes into the accused box. He must make sure all evidence, even if it exonerates the accused person, must be placed before court. And now you can see he's sort of selectively using certain evidence. And I mean, if we look at, there's Longwe Twala. Why is he not being called? Kelly Kumalo, why is she not being called? She wasn't the person that fought with these intruders, the intruder chaser. Don't you think that evidence is important to say those type of things? Longwe Twala was the one that first dived even one of these intruders out of the way to get out, to go and get help. To come and find out, did he get help? Where did he go? Because he disappeared from the scene right from the get-go, and nobody's asking questions about that. For me, so I'm a little bit worried about what I'm currently seeing.
Thank you so much for your insights. That is Elton Hart from the UJ Law Clinic, just unpacking one of our most talked about trials of 2023. There's still much more that we're going to unpack, but for now, thank you so much for joining us and see you next time.
The University of Johannesburg, the future reimagined.